Wambua Kinyili Mutunga, Charles Mutinda Market.
Okay, Paul Wambua for who is not present? Meleta Netos, ndio. Nataka mwakie in the following order. Wa kwanza kwa Duncan Wambua, wa pili Dennis. Dennis Wambua. Who is the second respondent? Yeah, the second.
Yes, sir.
Fungua ya uchakuji. Simu. Ama kifungui. Kifungui ilipotea. Order because I'm addressing all of them in the order in which they are appearing. Okay. So afuatwe na Wambua Kinyili Mutunga kwa watatu. Alafu Charles Mutinda. So this is the ruling. So 21, 31, 59 hours. Again, by about 4 minutes later, that is at 21:35, by an SMS on 5th of June 2024 at 9 was used by the internet. EMI ends with 48. The EMI was for the second respondent, Dennis Mutunga. He had obtained the handset which he had taken, and to confirm that the phone, that is the device 480, that ends with 480, which he signed, and 2 other witnesses. That is the second accused person selling the handset. Inspector said EMI was Samsung. He said that he had taken it to cybercrime for investigation. The father said that an explicit memo, which is CCU 977 of 2020, forensic headquarters. On the 5th of June 2024, the said handset was in possession of the first respondent, that is the first accused. They cited several other occasions before the arrest of the spoke on the same day at 9:59, and the second accused called the first accused and answered. The second accused was at the time in Machakos. According to the respondent, whose number was in constant communication with the first respondent, had called the complainant using this in that IM number and threatened him. Previous criminal records. They have presented previous criminal records. The first respondent, Duncan, charges at Machakos Police Station being case number 440, charges of stealing motor vehicle, that is criminal, case number 440, an offense of stealing by servant. For the second accused, Dennis Mutunga, the I observed. According to him, the Arraigned Police Station, CR 44B 173 of 2006, the offense is of defilement. Another one is Machakos Police Station, CR. Given that his client had complied with all conditions, please mute.
Wale tuko different tools. Wakati kupata time ya kuchambua so probably tunaomba tafadhali kama inawezekana mwezi wa 3 ndio nikuja nikiwa tayari kila kitu.
Tarehe ngapi mwezi wa 3?
Pia wanasema kuna statement zimebaki. Ndio tu kupata zote.
He was early March.
10th of March.
Tarehe 10 March. Wambua short for him, he is asking a date in March, and we are proposing the 10th of March. 10th of March. I'll just give that. Okay. So hearing on 10th. Nani wengine mmekubaliana ama mnakuja? Kwa sawa. prosecutor, you can have the matter mentioned for 14 days to just confirm that he has the OB that he was asking for and any other documents that you are still holding that is yet to be supplied, has been supplied to them. So give me a date in 14 days. But this can be done in prison. This measure shall be done in prison. If the prosecutor confirms that he has them, those documents, then you can be produced to have them handed over to you the following week. Okay?
Mention on 10th of February.
The mention on
10th of February.
Okay. Very well. So. Next. Opponent, do you have, or rather the second accused person, do you have anything? Are you think otherwise that we should proceed tomorrow?
I want to but I will put the board to see tomorrow.
Charles Muchindo.
Civil suit number E002 2025.
Council, let's deal with that civil matter at 11 because it's going to eat some of my time. And let me just go through the criminal matter, then you can engage in something and deal with that particular matter from 11. Thank you.
Criminal number E215 of 2022. Bernard Muitandumu. Bernard Muitandumu. What are they?
But they are drawn from the communication that happened inside this. I can also because nahitaji kutoke na kitu concrete hata ukihitaji
Sayang. Tele. Tele.
Mjue kwamba the evidence that has been presented, the court has considered them on interim basis. When the bulk of the evidence produced, the court can still make a determination as to whether whatever has been presented is sufficient to still keep you in, or you can still have your bond. Okay? But for the time being, escape has not been cancelled in total. It can always be reviewed based on how the case will progress. Okay? So, okay. This client had complied with bond conditions, including securing a title deed whose value had been done and found to be Kenyan shillings 5.5 million, and the same registered with the land registrar. He saw the bond be approved with reasonable conditions. On his part, the second respondent said there was no record of threat to the complainant, there was no complaint made in OB number 17/01/5/2024. He demanded its production in court. He claimed the allegations of threats are being said to have taken place when he had not been arrested. He claims that no such threats took place. In his submissions, the second accused conceded to having previous criminal records, but contended that he had transformed. For the third and fourth accused, the IO had no call data against them or previous record. Now, from what has been presented, there is evidence that indeed there are communications from a SIM card through a phone alleged to have been in possession of the second accused person made to the complainant and to the first accused person. The second accused has challenged the number alleged to have used to call the complainant is his. At this point, it is profound that court restrains itself because the bulk of evidence can only be ascertained after forensic analysis by DCI of the phone and the data received from the telco. But what has been produced so far is sufficient to draw a reasonable conclusion that there is a nexus between the call made by the complainant and the first and second accused person. There is no doubt the same was made before the arrests were effected, but nonetheless they were made after the alleged aggression against the complainant. For whatever reason the calls may have been made, which can only be adduced after hearing and ascertainment of the evidence in total, the fact that they may have been a threat cannot be treated lightly. The fact that stands uncontroverted is that the calls were made and there is reasonable evidence that the same were linked to the first and second accused persons. Further, there are evidence of previous conviction, previous criminal records for both the first and second accused person, and for which the outcome in respect of the first accused have not been ascertained, but for the second accused he has conceded to, but says he has changed. It is for the above reason the prayer by the state for cancellation of the bond shall be allowed for the first in respect of the first and second accused persons. Now for the third and fourth accused, nothing has been provided to link them to the communications, or rather to any communication to the complainant. There is further no evidence of previous criminal records. It is for the said reasons that the bond term set herein shall remain in favor of the third and fourth accused persons. Okay, so that's my ruling.
Mlalamishi wa kwanza na mlalamishi wa pili mmekuwa na ushahidi kwamba mlikuwa mpigia ama mliweza nyinyi mkaweza kuongea na pia mliweza kumpigia mlalamishi wa hii kesi. So court ime cancel condemn for first and second accused person. Kwa mlalamishi kwa third and fourth accused person hakukuwa na ushahidi wa kutosha kuonekana bond ilikuwa cancel. So koti itawapea nyinyi bond iliyokuweko ambayo ni bond of 5 million. Sawa sawa.